Our next speaker, I'd like to introduce Kate Berger, who is an attorney in the Department of Labor and Industry's Office of General Counsel. In addition to being an attorney, Ms. Berger is a registered nurse, so her experience is particularly sought out in drafting workers' compensation legislation, rulemaking, and compliance. Today, she will review case law that we hope you will find useful in your practice. And now, Kate Berger.
Thank you, Chris. In the next half hour, I'm going to give an overview of 7 cases from the Workers' Comp Court of Appeals and the Supreme Court. I only have about 5 minutes a case, that means, so I can't review all the facts and analysis, but each slide contains a summary of the cases by the court, and it's followed by a link to the case. So if anything that I mentioned today kind of piques your interest, it'd be a good idea to go ahead and take a look at the case and see all of the facts. See all of the facts and the analysis provided. Due to the short time frame, we don't have time for questions during the next 30 minutes, but please submit them anyway, and we will take a look at them. Or we will answer them at the question and answer period at the end. So let me bring up okay. So let's see. So the first case is the Smith versus Kmart Sears Holding Company. It was issued in January 2019 by the Work Comp Court of Appeals. And in this case, the Court of Appeals affirmed the compensation judge's decision that the employee was not a qualified employee due to the effects of the injury under the definition of at issue was payment by the court. At issue was payment of a 18-year-old employee the summer before his senior year of high school. He returned to work with restrictions and continued to receive chiropractic care into November. And then in November, he resigned working at Sears because he only wanted weekend hours so that it didn't interfere with his classes and his grades. But the employer continued to schedule him during the week. The employee acknowledged that he did not resign due to his injury. Around the time he resigned in November, the QRC contacted the insurer for permission to conduct a rehab consultation. And during the discussions, the insurer agreed to medical management services. The QRC conducted the consultation on December 2nd and found the employee to be qualified for rehab services. The insurer received the consultation report on December 20th, 2016, and the next day emailed the QRC and the employee's attorney stating that the employee was not qualified for rehab services. The QRC testified at the hearing that she understood the insurer was disputing her services and that she was providing them at the risk of not being paid. On December 30th, the employee filed a rehab request seeking approval and payment of ongoing rehab services. On January 3rd, 2017, the QRC filed an R2, and in response, the insurer again reiterated that it would not pay for services after December 21st, the day it received the consultation report. At the end of January, the employee started a part-time job at as a restaurant chef, but this only lasted for actually less than a week after the previous chef this week of employment, and an order for job monitoring for 30 days was issued following an administrative conference, but this became moot because the employment ended. At a hearing at OAH, the employee argued that the rehab services should be paid because despite the insurer's statements that it would not pay for services after December 21st, the insurer essentially agreed that the employee was a QE by authorizing medical management in November, and because a mediator's order that the QRC monitor the job that lasted less than a week. So a compensation judge determined the payment for the denied payment for the rehab services because on the basis that the employee did not meet the requirements of of a qualified employee due to his work injury. The employee resigned from his date of injury employment to focus on school, which is a reason unrelated to his employment, to his injury. The employee's injury and restrictions did not prevent him from continuing the date of injury employment with Sears. And so therefore, because services should not have been commenced in the first place because the employee was not a QE, the court found no need to analyze whether the services were properly terminated under the Supreme Court's Halverson decision, which provided that the employer-insurer, again, must establish good cause to terminate rehab services. But in this case, it should never have been commenced, so the case didn't apply, the court found. The QRC, therefore, was not entitled to reimbursement for services on or after the first day that the employer-insured disputed for consultation determination that the employee was a QE. And the court noted that the QRC knew that the insurer was denying liability, and denying that the employee was a QE, and knew that there was a risk that services would not be paid. The employee also requested temp total from when the restaurant job ended to when he was released to work without restrictions a few weeks later, but the court again noted that the employee's desire to limit his work hours to weekends was not due to his injury, but rather due to his studies, and therefore temp total was also not payable. In the Winstead case, I'm forgetting to advance my slides here. Hang on. In the Winstead case, the Workcomp Court of Appeals affirmed the compensation judge's decision at OH that a rehab provider who filed a rehab request, which was not certified as a dispute, and was dismissed for lack of jurisdiction, and who was advised to file a motion to intervene but failed to do so, was not a party, and its interests were extinguished by operation of statute and was not entitled to a Parker-Lindbergh hearing. So in this case, what happened is that in March, the employee's attorney simultaneously filed a claim petition for various benefits for an injury, an alleged injury in January 2017, including vocational services and a rehab request seeking to have a QRC provide rehab services. No intervention notice was given to the QRC. Then the employer filed a rehab response denying primary liability and referring the employee to the vocational rehab unit at the department. And the employer's attorney mailed the request to the rehab provider and also sent him a letter saying that they are denying liability and payment for any services that would be any rehab services provided. Shortly after the insurer sent this response and the letter, the QRC performed a consultation and found that the employee was qualified to receive rehab services. After receiving the report, the employer filed a rehab request to terminate services because, again, it was denying primary liability and because the employee was not a qualified employee. A compensation judge consolidated the employee's claim petition and the employer's rehab request to terminate services. So in June and July, the rehab provider continued to provide services and, in fact, filed his own rehab request with the department seeking payment for outstanding invoices for rehab services provided. The rehab provider also sent a letter to the employer noting that the case law allows rehab providers to provide services on denied claims as long as there is an understanding that the rehab provider is taking the risk of non-payment. In the letter, the provider asked to be included in any settlement discussions. The employer's attorney then sent the QRC a potential intervener notice, including a copy of the claim petition and information on how to file a motion to intervene. Meanwhile, DLI notified the rehab provider that it did not have jurisdiction over the rehab request in light of the primary denial of liability and would take no further action. DLI's letter also advised the QRC to contact the employee to determine whether a claim petition has or will be filed and whether there's any matter pending in which the rehab provider could intervene. So then in August, the employee and employer began settlement discussions. And remember, the QRC had not intervened and so was not included in settlement discussions and no settlement offer was extended to him. But on September 5th, the employee's attorney did notify the QRC that an agreement had been reached between the employee and employer. And 2 days later, the QRC prepared a rehab plan closure report. Now, the stipulation for settlement that was signed by the employee, employer, their attorneys, included a statement that both the employee and employer had been prejudiced by the failure of the provider to timely intervene, and that the QRC's potential intervention interest should be barred due to its failure to intervene after receiving notice of the right to do so. A compensation judge issued an award on STIP with an order closing out the rehab provider's potential intervention interest. And 5 days after the judge's award, the QRC requested a hearing at OAH for payment of outstanding charges, and he retained the employee's former attorney to represent him. The compensation judge concluded that the rehab provider was not an intervener and that the issue of whether it was effectively excluded from settlement negotiations was not properly before her. And so the rehab provider appealed to the Work Comp Court of Appeals. So the Work Comp Court of Appeals first acknowledged that interveners are entitled to protection under the Work Comp law, that an intervener who is excluded from participating in negotiations resulting in a settlement should be awarded full reimbursement by the settlement award, and that the intervener is entitled to an opportunity to be heard on the issue of whether the intervener was effectively excluded. These are often called the Parker-Lindbergh hearings after a Supreme Court decision that established these intervener rights. At the hearing in this case, the rehab provider argued that it effectively became an intervener because it had filed a rehab request. And this was based on two previous Work Comp Court of Appeals cases where providers who had filed rehab requests were considered to be parties even though they hadn't formally intervened. The Work Comp Court of Appeals declined to apply these cases here because they said both of those previous cases allowing party status to providers who filed rehab requests without intervening, those involved admitted injuries, rehab requests that were filed and accepted, settlement discussions that occurred while the rehab requests were pending, failure of the parties to provide statutory notice of the provider's intervention rights, and the rehab providers took additional action to seek payment before any stipulation for settlement was filed. In this case, none of those facts applied. So the Work Comp Court of Appeals held that once the rehab request was declined for lack of jurisdiction, the provider's only remaining recourse was to file a motion to intervene, which it did not do, and therefore its interests were properly extinguished and the provider was not entitled to a Parker-Lindbergh hearing on its right to reimbursement. I will also note a couple of other things. In August, Minnesota Supreme Court issued a decision holding that a healthcare provider who did not intervene after being given notice of the right to intervene cannot later file a separate petition for payment of medical expenses with the Office of Administrative Hearings. And that case is Conan versus Flagship Marine Company, Koehnen, and you can find that on the Work Comp Court of Appeals website. Even though it's a Supreme Court case, they also publish the Supreme Court cases. And finally, I will note that there is a statute that provides a procedure separate from the Parker-Lindbergh. It provides a procedure for a hearing on the intervener's right to reimbursement when the employee and insurer do not reach agreement with the intervener, but they still want a partial settlement of the employee's claim. And that statute is in 176.521, and I would encourage you to take a look at that and become familiar with it because it does provide some additional protections for interveners. So slide 4 is the Ewing versus Craft decision. And this is both a Work Comp Court of Appeals and Supreme Court case. In this case, the comp judge denied payment for rehab services because the employee had recovered his injury. Again, this case, the Halverson case is discussed in these cases. The Work Comp Court of Appeals decided that the QRC was not barred from payment for service provided under a rehab plan until the insurer filed a rehab request to terminate the plan. even though the work injury was temporary and had resolved before the plan was terminated. This analysis was based again on the Halverson case and was appealed. The employee injured his ankle in December 2015 when he slipped on ice. He later developed other symptoms and conditions that he alleged to have been consequential injuries, including complex regional pain syndrome, arm, shoulder, back, neck pain, and spasms, insomnia, headaches, depression. Medical treatment was provided for these symptoms. In April of 2016, the employee was taken off work due to the effects of the injury, and the QRC concluded that the employee was qualified for rehab services due to his restrictions. The QRC filed an R2 in July to initiate rehab services, including medical management and return to work. The self-insured employer did not object to the R2 when it was filed. In January 2017, the employee was examined by Dr. Friedland on behalf of the self-insured employer, and he concluded that the employee suffered a mild left ankle strain that was temporary and would have resolved by April 20th. In February, then, 2017, the QRC filed an R3 amending the plan to extend medical management, and again, the self-insured employer did not file an objection. In April, the self-insured employer filed a rehab request to terminate the rehab plan, and the QRC continued to provide services in the form of medical management after receiving that notice. The comp judge agreed and found that the employee's work injury agreed with the IME report, finding that the employee's work injury was temporary and resolved by April 20th. And the judge ordered that all claims through April 20th be paid, but dismissed all claims after that date. So then the Work Comp Court of Appeals reversed the compensation judge and ordered payment of the rehab services through April 6th. Now remember, the IME report found that the employee's injury had resolved as of April in 2016, a year before then, because April 2017, because that was the date the rehab request for assistance was filed to terminate the plan. So it was appealed to the Minnesota Supreme Court, and in January 2020, the Supreme Court reversed the Work Comp Court of Appeals, concluding that the comp judge correctly held that the employer was not liable for rehab services after the date that the injury had resolved, which was April 20, 2016, thus making those services neither reasonable or necessary. So a key fact in this case is that the employer and insurer did not appeal the compensation judge's decision that the employee's injury had resolved by April 20th. The QRC did not challenge the comp judge's factual findings regarding the employee's ineligibility for treatment either after April 20th, and did not assert that there was that those findings lacked substantial evidence. Therefore, the question before the Supreme Court was only whether the Work Comp Court of Appeals correctly concluded that the employer was required to show good cause to terminate rehab services that were provided after the date the injury resolved. The QRC relied on the Halverson case, again, where the Supreme Court held that the plan modification provisions of the statute 176.102 requires an employer to file a request and then make a showing of good cause before terminating an employee's rehab services. But the Supreme Court said that this whole Halverson case that is so frequently cited applies only if, first, an employer has admitted primary liability for a work-related injury, or a judge had previously ordered the employee to pay for work comp services, and second, the QRC provided rehab services related to that compensable injury. In this case, the court said that these conditions did not apply. The Supreme Court decision contains a thorough review of the statutes, rules, and cases governing rehab services, probably worth a read. But the final conclusion of the court was that none of the rules and cases impose ongoing liability for rehab services after an employee no longer has restrictions. In addition, the court noted that the QRC knew eligibility was disputed and understood the risk of not being paid in light of the dispute. So the next case is Farr versus St Paul Cafe, issued in June 2019. In this case, this has to do with disability case management. The Work Comp Court of Appeals vacated the compensation judge's decision, holding that the Work Comp courts do not have jurisdiction to impose limitations on the right of an employee to change a disability case manager. This was a permanently totally disabled employee. Rehab services had been closed in 2013 by an agreement. And after voluntarily providing disability case management services, the employer insurer decided they wanted to change the case manager, although the employee was satisfied with the services. So the comp judge approved the change of DCM requested by the employer insurer. The employee objected to the change and appealed. And the Work Comp Court of Appeals noted that disability case managers are generally employees or agents of the employer insurer. They are not governed by the rules governing QRCs. And therefore it held that disability case management services, because they provide non-statutory benefits, that the Work Comp courts, WCCA and OEH, do not have jurisdiction over those services. The court said that therefore the employers and insurers may make changes to these without filing a medical or rehab request or otherwise seeking approval. The court noted that the Work Comp Court of Appeals has no authority to advise employees or employers and insurers on the mechanics of voluntarily provided services. So what does this mean? I think the court says that it does not have authority to advise the parties about the sort of the procedures for voluntarily providing non-statutory services. It seems that the corollary to this decision would be that the courts also would not have jurisdiction to require the employee to accept DCM services from at all or from a specific DCM provider. However, there is one statutory provision related to DCM services in 176.102 subdivision 10. It does provide that an individual QRC registered by the commissioner must not provide any medical, rehab, or disability case management services related to an injury that is compensable when they are part of the same claim unless they are part of an approved rehab plan. This statute was not an issue in the case, but since it is actually in the work comp statutes, presumably the judges would enforce this statute in cases that come before it. So slide 7 is, the next case is Washuk versus New Dimensions Home Healthcare from Work Comp Court of Appeals case from August 2018. In this case, the WCCA affirmed the compensation judge's decision that the base cost of an accessible vehicle is compensable as a rehab expense, where it would allow an employee with paralysis to function independently and seek and engage in employment. In this case, in 2002, the employee was a 22-year-old employee of a home healthcare agency and sustained catastrophic injuries while working for the employer when her vehicle was struck by a semi-truck. The employee is permanently totally disabled and has an almost 95% PPD rating. This case has been extensively litigated over the years. In March of 2016, the employee's rehab plan was amended to having an employment specialist develop job leads. And returning to work was always the employee's #1 goal, she testified. She emphasized that having a job was so important to her and that she wanted to be like everyone else. So in July of 2016, the employee began working 8 hours a week at Shopko, which was about 28 miles away from her home. And in April, the employee filed a claim petition for payment of the base cost of a 2014 accessible van. The employer insurer denied the claim as not being compensable. And after a hearing, although the employer insurer did pay for the adjustments to the van so that she could drive it, but they didn't pay for the underlying cost of the van. On appeal, the employer raised 2 issues. First is the cost of the base cost of a vehicle, a reimbursable rehab expense under the work comp law as a matter of law. And second, if it is compensable, whether the evidence in this case supports the need for the van, for the base cost of the van. The Work Comp Court of Appeals noted that the employer and insurer have sole responsibility for paying the cost of necessary rehab services provided, including the cost of all rehab services and supplies, and they emphasized the word supplies necessary for implementation of a plan. And they noted that many types of reasonable and necessary rehab supplies are not directly listed in the statute, but would be reimbursable anyway. So unlike the statutory limit on remodeling costs, the court noted that the liability for rehab costs is not capped for each personal injury. And instead, the test is whether the cost of all rehab services and supplies are reasonable, necessary, and causally related. Therefore, the base cost of an accessible vehicle is legally compensable as a bulk rehab expense. And so the next issue was whether the van enabled the employee to seek and engage in employment, as the compensation judge determined, and the Court of Appeals concluded that there was evidence to support this. The employee was searching for work under a JPPA. The van was used for transportation to and from work, and there was no publicly accessible transportation where the employee lives. It's non-existent, the court found, and private transportation would be cost prohibited. They also noted that the employee was highly motivated and physically capable of returning to work, compatible with her restrictions, qualifications, age, education, and labor market conditions. And so therefore, because the 2014 vehicle was necessary to enable her to achieve her vocational objectives, the van was compensable. The base cost of the van was compensable. So the last case, I'll talk quickly here. The Work Comp Court of Appeals affirmed the compensation judge's decision approving a retraining plan considered the employee's potential for future earnings as well as her date of injury wage. The employee was earning her bachelor's degree in aquatic biology when she took a job as a seasonal naturalist at Fort Snelling. And, oops, sorry here. Well, I'll just quickly finish the, I don't know what happened to my PowerPoint, but I'll quickly tell you that in this case, the compensation judge awarded retraining benefits, argued that the compensation judge erred as a matter of law by considering the employee's speculative earning capacity for intended career as a fisheries specialist. This employee was earning her bachelor's degree in aquatic biology when she took an internship position for a summer, and right after she started, she was injured. The internship paid $12 an hour. She was eventually diagnosed with CRPS. The employee had completed 2 associate degrees and 7 months after her injury completed a Bachelor of Science degree. And her goal was to work as a fisheries specialist with the DNR. So the employee testified that she was physically unable to perform the duties of her intended career because of the work restrictions. And so they began looking into retraining. And decided to retrain her as a medical assistant by getting another Associate of Arts degree at Hennepin County Technical College as a medical administrative assistant. So in affirming the compensation judge's award of retraining, the Court of Appeals noted that the employee is eligible for rehab benefits if the injury prevents him or her from returning to former employment or from securing advancement in that employment. And the court also noted that the Work Comp Law 176.102 specifically provides that rehab to a job with a higher economic status would be permitted if it can be demonstrated that this rehab is necessary to increase the likelihood of employment, and that economic status is to be measured not only by the opportunity for immediate income, but also by the opportunity for future income. So since it was legally appropriate to consider the employee's future earnings in approving a rehab plan, the next issue is whether the judge's decision awarding it was supported by the full training factors. And in this case, the court analyzed those factors and determined that they did support retraining. And retraining was likely to produce a reasonably attainable employment and an economic status as close as possible to what she would have otherwise enjoyed without the disability. labor market survey indicated the work was available for this and that she would be able to do it, and have a starting wage that approximated, if not exceeded, her date of injury wage. So the court also noted, as with all of these cases, that the propriety of proposed retraining plan is a fact issue for the compensation judge, and agreed that the judge's decision awarding retraining was legally appropriate. So there we are. That's the end of my presentation. Again, please submit your questions if you have any, and we will try and get them at the question and answer period at the end of the day.
Thank you, Ms. Berger. That was wonderful. And again, at 3:35 will be the Q&A where you can pose questions to Kate.